All right, everyone, we have made it now to the 15th chapter. This is the last of the chapters that we'll be covering for our final, and also the last set of chapters that we will cover for our midterm exams. It's been quite a semester. We still have, of course, a few weeks left, so let's make those very productive weeks. And now we're beginning our coverage of the Supreme Court. The plan will be that we'll have 4 recordings on the Supreme Court, 4 different lectures. So this one will focus on the impact that Supreme Court decisions have on our lives. So our lives are changed as a result of Supreme Court decisions. And we've really covered the Supreme Court throughout this semester. So here's a chapter that really will focus on the court, of course, and it's also looking at the federal courts. But starting really in chapter 2 especially, we've been covering some segment of the Supreme Court. So in some of these slides, we'll just be reminding ourselves of what we've already covered on the Supreme Court. Now let's keep in mind that when we look at the Supreme Court and the power of their decisions, that they are going to have as a basis of that decision some segment of the Constitution. So it's their interpretation of the Constitution and the acceptance of that interpretation by other segments of power in our system that give the court its power, its influence. So I have an asterisk by court cases that we have covered in class. And probably we can remember going back to chapter 5, the importance of Brown versus Board of Education. So in this case, a unanimous decision that having a segregated school system based on race, which is essentially at the time was also skin color, is what that meant. And I suppose to some degree that's still the case, that was unconstitutional. That was a violation of the 14th Amendment, an amendment that we see coming up in many cases. This is certainly a part of the class that would hope that you will continue to remember. I know we've covered a lot of material, and the ability to cover everything and remember everything is somewhat challenging. But certainly the parts about the importance of the Constitution and different segments of the Constitution can be very important to remember. So remember equal protection under the law, that there is not an equal protection under the law if you have segregated schools. The right to an attorney found in the 6th Amendment, does that extend to the right to an attorney even if one does not have the financial means to afford an attorney, and the state would provide a defense attorney? And that was the ruling in Gideon v. Wainwright in 1963. The right to privacy means the right to privacy for sexual acts, in this case involving same-sex couples. We're dealing with adults here, of course, but in that case, a sexual act between a same-sex couple is protected under the right to privacy. That right to privacy that was there for heterosexual couples is now extended to homosexual couples. And the basis of that is the right to privacy found, interpreted in the 9th Amendment. What does it mean, the right to bear arms? In the city of Chicago at one time, you had only the right to have a handgun, but not a shotgun. And so in that case, then citizens would have the right to have a shotgun, that all arms were part of the 2nd Amendment. So in this case, a landmark case, because there had not really been a Supreme Court decision involving the 2nd Amendment and interpretation of the 2nd Amendment before McDonald v. Chicago. So then that became then the basis of the 2nd Amendment. A couple of cases that we've not covered but also involve, and we can see here the First Amendment. that violent video games are protected under the First Amendment. And in the state of California in 2005 had passed a law that it required that some of these particular violent video games were banned to people under the age of 18. And the Supreme Court overruled that it was a violation of the First Amendment. So who has access to what games, and is there a limitation to the First Amendment? The courts, by and large, said there was not a limitation to the First Amendment when it comes to video games in this ruling, and that it was mainly up to families to make that decision, not the government. If you had police put a GPS device on a car, then that was in fact a requirement for a search. It required a search warrant. And so that was then the Fourth Amendment. It would be a violation of the Fourth Amendment to put a GPS device on a car without getting first a search warrant. So the ruling in United States v. Jones. We can see also then, so the most recent cases there were roughly around 2011. Since that, as we can imagine, there's been some other very important cases. And so beyond just the amendments dealing with individual freedoms and individual forms of expression, we have here going back to the original Constitution and the articles that would outline the powers of the different branches of government. So for example, the powers of Congress in King v. Burwell, 2014, you have then the ruling that the Affordable Care Act is constitutional. So requiring people to buy insurance is deemed a tax, and Congress does have the power to raise taxes. So that was the basis of finding the Affordable Care Act to be constitutional. We can also see in 2015 the ruling that same-sex marriages are constitutional and are then nationwide, apply to all states according again to the 14th Amendment, equal protection under the law. We can also see then some other interpretations. I throw in the case Glossop v. Gross in 2015, dealing with the drug midazolam, and that could it be used in executions. This was not part of the original cocktail for executions under lethal injection, but could it be included, or would it be a violation of the Eighth Amendment? So the cruel and unusual amendment. Now let's keep in mind, the reason why mainly I included this case is that this involved the state of Oklahoma, a convict in the state of Oklahoma who was subject to execution and would be administered this drug. But the courts, and so that there was a challenge, and the courts ruled that it would not be a violation of cruel and unusual punishment to have midazolam used as part of the drug cocktail for the execution. This is an interesting case as well that we see here. You can see the second case, Michigan versus Environmental Protection Agency. So notice the statement here, ruled that the agency did not interpret the Clean Air Act correctly by not considering financial impact on companies when enforcing regulations. So this comes back then to Article 1. So in some ways, when you're saying there wasn't an amendment here, there was the article, the powers of Congress being interpreted by the court. And the Supreme Court interprets, enough members of the Supreme Court interpreted that Congress can instruct a bureaucratic agency that it is constitutional, it's protected as the power of Congress, that the Environmental Protection Agency needed to consider the financial impact, and when they were being instructed by Congress on how to enforce a regulation. That's the power of Congress, according to the Supreme Court. And again, we see the power there of the Supreme Court. We talked about this case. This is going back again to Chapter 5. So we're looking at what's referred to as the Fisher case, Fisher versus University of Texas. And so in this case, can consider race as part of its admission criteria. So we know that this has been a controversial area. And if you recall, we talked about strict scrutiny, meaning that the burden of determining that race can be considered a reason for admission, a reason for dismissal, any type of factor involving race becomes part of the strict scrutiny rule, and that generally is not allowed. But in this case, it was not a violation of the 14th Amendment. And that's part because this was only a one segment of the reason for admission into the University of Texas. So there were other reasons. And so to say then that this would ultimately lead to the explanation why someone did not get admitted was hard to prove. And so, again, looking at the issue of equal protection under the law, not a violation of that, and the way the University of Texas was doing this, to also include race as part of its admission factor. And then we look here just recently, coming back to, again, think about, in this case, Chapter 4 and the Fifth Amendment, double jeopardy, not to be tried twice for the same crime. But notice here that in Gamble v. U.S., that the court made the conclusion, and we can see the power of the court here, that it's not a violation of double jeopardy for a federal court to try a person found not guilty of a crime in the state court. So this is where a case where a person could be tried, found not guilty in state court, and then tried in the federal court, and it's not a violation of double jeopardy. Which brings us to this year and some of the important cases that we can see here. So dealing with the presidency, Article 2, Trump v. Vance, and Vance is a district attorney in New York. And in this case, we can see here the president does not have absolute immunity, and a grand jury can demand documents to investigate potential crimes. So this was an attempt to what degree can a president be investigated while the president is in office? And that's been an ongoing question. This goes back to Richard Nixon and also cases involving Bill Clinton, and now we see cases involving Donald Trump. So can a grand jury have the right to look into documents that may consider a president's taxes, a president's financial holdings, and as part of an investigation? And the court ruled there is not absolute immunity. This is important when we consider that, and this was before the most recent Supreme Court justice, and we'll have this for another recording, but you have a president in which this decision is being made by justices, in part at least, that the president had appointed. But once they're on the court, are they not supposed to now just focus on the interpretation of the Constitution? I think a case that probably should get more attention in our culture is to look at Bostock versus Clayton County. The Civil Rights Act of 1964 extends to LGBTQ community. the 14th Amendment. So once again, what's the Civil Rights Act about? And this is an interesting case in many different ways. Certainly, we can see here the extension culturally in this case. So to discriminate against someone because of their sexual orientation is a violation of the Civil Rights Act, according to the majority on the Supreme Court. Now, what's interesting here is that that segment of rights, or that population, was not originally included in the 64 Civil Rights Act. But you have a Supreme Court interpreting that that is where society is now. And so that's not an accepted discrimination, even though that was not mentioned in the 1964 ruling, in the 1964 law. So again, we're left with, does the law and interpretations evolve, or are they supposed to be stagnant? And so you had some members of the court saying, you can't extend that right because it's not in the act. That those populations are not in the act. And then you had enough justices say it is an extension. It should be extended, even if they were not mentioned in there, because that's where society is. The expectation that there should be protections for these populations, for these communities. So this is a really interesting case, and certainly in the new textbooks when they're coming out, this case will certainly be mentioned. First off, just the overall impact that it has for a considerable group of people in the United States. But secondly, what is the basis of the law? Do you interpret the law that it's intended to evolve based on the needs of society, or do you only look at the law based on what is written down? And so we continue to see that debate in our society and in the law in many ways. And we have a case involving the First Amendment dealing with religion, Espinoza v. Montana, also this year. If a state provides assistance to private schools, it cannot discriminate against private religious schools. So we had a situation in Montana in which there was a voucher of $500 for students going to private schools in Montana, but not to private religious schools. So that was deemed by enough members of the Supreme Court, this was discrimination. If you're going to provide a voucher to students going to a private school, you can't then discriminate and not provide that voucher to students going to a private religious school. Now, one remedy to this is simply to not provide a voucher to a private school. But if you are going to provide it, you can't discriminate. And so, it's one way of looking at that. It would not be accurate to say that that is giving a benefit to people going to a private religious school. It is just providing a blanket voucher for anyone going to a private school. And so Montana does have the opportunity to remedy that if they don't want to give funding to people going to religious schools. Now notice, it's not saying particular religious schools, right? Any religious school now that would be opened up in Montana, and if they're continuing the voucher to private schools, then it would go to Catholic schools, it would go to Protestant schools, it would go to Muslim schools, it would go to Buddhist schools in that case as well. And then probably a case I would think many of you here are familiar with, McGirt v. Oklahoma, a landmark case. And it is having an impact here in eastern Oklahoma. Oklahoma does not have the authority to prosecute serious crimes committed by Native Americans on land that was part of a historic reservation. And this is again coming up with Article 1. Congress negotiates with American Indian tribes. I think they're referred to as Indian tribes. So in that situation, the ruling was that there had never been a resolution to the land of, in particular, Creek Nation. And so when this is happening on what is supposed to be reservation land, or what may have been reservation land, was considered to be reservation land, and no longer, in no specific way of ending that has to now be a case in which you're bringing in Native American police and perhaps federal authorities to resolve this matter, this criminal prosecution. So who exactly is responsible for the land, and how are the treaties to be interpreted? Still an ongoing issue. So that leaves us here with a question for chat. What issue or issues do you believe the Supreme Court needs to review? So we've looked at so many different ways in which the Supreme Court has an impact on our lives. Is there something out there that you think the courts need to review and kind of resolve for our society? Good question for chat. All right, that's what we have for today on the Supreme Court. The next time that we're together, we'll look at the members of the Supreme Court and the powers of the Supreme Court Chief Justice.